Hello, welcome to another UTS Startups Confessions. Okay, are you worried about your startup getting sued out of existence? Well, that was more people than I was expecting. Or are you interested in what might be patentable and understanding what's kind of out there in terms of protection? Yeah, I am. And I'm really lucky, and we all are, to have Chris Baxter here today from BaxterIP. There is no one I would go to above yourself, Chris, in terms of advice in this area. You're amazing, and you've helped so many people over the years. Tell us a bit about BaxterIP, and then we'll dive into the useful stuff.
It's an easy question to start with. So we're a boutique IP firm, started in 2007. We've got about 20 staff, and we do patents, trademarks, and registered designs, IP strategy, IP audit. On the patents front, we handle tech across all technology areas. My personal portfolio has a few little, areas where I've ended up doing more work in than others, and they are software, medical devices, and defence. So a rather eclectic sort of mix of things there, but yeah.
I remember it must have been like 2007 or something when you're starting out, but you were the first person I asked for patent advice.
Oh, really?
Under AdMunch, you probably don't remember, but I was quite impressed back then, and now you've got like 2,000 clients simultaneously that you're supporting in startups.
Yeah.
So, when should people think about patent protection?
Okay, yeah, and just to say my answer would be different if you'd sort of asked about IP generally, because trademarks, registered designs, and patents all have sort of a different point you want to be thinking about.
Okay, let's go through this.
Yeah. So for patents, the key date is called the priority date, and the priority date is the date a patent application is first filed, and it's the date that ends up being recognised right throughout the patent process by various patent offices around the world, if you end up going internationally, as the date you've laid a claim to the idea. You put the flag in the sand. And it's also the date at which it's sort of the cutoff date for whether any given publication is part of the prior art base or not. And the prior art base is that group of documentation your patent will be assessed against in terms of novelty and inventive step. Sorry, that was we sort of went right down and then back up. For trademarks, you can file a trademark at any time, even after you've started using the brand or even years down the track. In fact, the longer you've been using a trademark, the better the chance you have of registration, because you can show evidence of use and evidence of brand reputation in market. Whereas with patents, if you start making, using, selling a product covered by the patent before you lodge the patent application, you stand a very good chance of invalidating that patent right.
So if I walk around talking to investors or potential employees or blah, 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 everyone about this idea I've got?
Under a confidentiality agreement at least, but one is, well, it's much safer to have that sort of independently standing IP right, the patent lodgement at the office.
Okay. Maybe it's worth going back to the novelty and inventive step part of things, because I saw some confused looks.
Oh yeah, they do require some definitions. So what I'm talking about are the requirements for a valid patent, and there's a bunch of them. But the sort of three, say for the purpose of today's discussion, three key requirements that are fairly consistent jurisdiction to jurisdiction around the world are that the idea must be patentable subject matter, and we'll talk about what that means in a minute, novel, and inventive. So let me say a word about each of those. Patents do not exist for protection of all ideas. If you have a new algorithm in sort of theory, not applied, or if you've made a scientific discovery, if you have a scheme or rules for a game, these things are not patentable. They just don't fall within the definition of a matter of manufacture according to the Patents Act. Now, I'm talking in Australian patent law lingo. Other countries have their own equivalent of that. But those things I just mentioned are not patentable in any country around the world.
Even like a compression algorithm?
Compression algorithm, definitely.
Yep.
But see, it's applied.
Okay.
It's not an algorithm. It's not like a mathematical algorithm in sort of like a standalone algorithm. It's a process a computer performs.
Okay.
Yeah.
So
there's a distinction to be made, and so maybe we'll pick up software patents, I'm sure, a little bit later in the interview. But just to cover the two other points, novelty and inventive step. So novelty is a strange word for new, which means there has to be at least one, if your invention is a product, there has to be at least one feature of the product that's new. If your invention is software or another type of process, there needs to be at least one process step that's new. And then the inventive step requirement means that whatever the feature is that is new, whatever the process step that is new, also needs to be not obvious to someone who's familiar with this type of technology. So, and the legal jargon for that is a person skilled in the art. And they're basically the three requirements for patentability. Is it patentable subject matter? Is it novel? And does it comprise an inventive step?
Okay. And then you get into provisional patents and full patents and different jurisdictions of patents and patent amendments. Do you want to run through those as quickly so people have a way of what actually comes up in that process?
Absolutely, yeah. So the patent process can sort of look a few different ways depending on business strategy, but I'll just describe the most common sort of patent process at a high level so we've all got some orientation around what it looks like. Normally the patent process starts by filing a provisional patent application. Most companies file them in Australia, some may start in the US. That then sets a 12-month time period within which you need to file a complete patent application. And that complete patent application can take different forms depending on where you're aiming to get protection. Typically, a complete patent application is what's known as a PCT International Patent Application, which covers, now I'm on camera, is it 156? Someone Google it for me. It's occasionally increments by one. Member states. The only country of, say, economic significance that's not covered under the PCT is Taiwan, which would need to be filed at the same time separately to a PCT. The PCT lasts 18 months after your first provisional 12 months, which gives you 2.5 years before you need to make a final selection as to which countries you want to pursue protection in. And so that's one of the benefits of not going directly to filing patent applications in each country, like a standard complete patent application in each country you want protection in. That 2.5 years allows you or your potential licensee to do some thought work around what jurisdiction we want coverage in, what jurisdiction is important to potential licensees, and also to resolve, the easiest way to say this is to resolve bugs within the specification, but bugs not necessarily being errors. But what we're trying to do is distinguish the claims over the whole international prior art base on those novelty and inventive step criteria. So there are processes within that first 2.5 years, searches and examination processes, to allow you to try and achieve an acceptable set of claims before you branch out into all the countries, so that you don't have to resolve the same issue in 10 different countries and cost a lot of money.
Okay. How much does a provisional one have to match up with what you end up filing? Because can you just do something super vague to start with, see what your competitors do, and then file something that's very similar to what the competitors end up doing as the amended full version?
Oh, yeah. Okay. So there's a few aspects to that. there's sort of, I call it like end patent strategy and nailing infringement. But there's also how to not shoot yourself in the foot by filing something that's too light on. So there's some pretty strict requirements under Section 40 of the Patents Act, which requires whatever you're claiming in the specification, whether it's a product claim or a process claim, you have to describe the best method you know of to implement that in real life, technically implement it. Because that's the quid pro quo of the whole patent system. We disclose to the public what our ideas are in relation to what we want this monopoly on, 20-year monopoly, and in exchange the government gives us that monopoly. So I guess the first part of the answer to that question is even a provisional patent application these days, particularly after a change to the Patents Act about 10 years ago, basically needs to be in the format of a complete international patent application. The specification is basically the same. If you do less, you're shooting yourself in the foot. Now, interestingly, when you get near the end of the process and you get a granted patent, your claims are forever locked in the form that are granted. So what companies that have the budget do is, take one step back. Once your claims are locked in, that's a bit problematic in terms of capturing an infringement, because the infringement may be slightly outside whatever claims are granted. So what you really want to do is not have to lock in your claims to a particular wording. You want to keep the option open for amendments, which you mentioned. So the way we do that, and I used to work at ResMed, where it's quite wonderful company, and had a great IP budget. And so what we used to do there, and this is all public record, and a lot of our other large corporates do too, is when the patent application is pre-grant, you then file a child application called in Australia it's called a divisional. It's called different things in different countries. But basically a child, like parent application's the first main one, then child application, child application, child application. So at any one point in time, you always have a patent application pending, which means that all times until the very last child is granted, you can amend the claims of that patent to capture, to nail an infringement, a competitor product. So patents are very powerful. And they last 20 years.
All the thinking faces, thinking about how you're going to leverage that. I love it.
Sorry, that was a long answer.
That was a fantastic answer. I mean, but it sounds like you need to, especially as of 10 years ago, put enough effort into that provisional that you're capturing something that ends up being useful to other people down the track if they want to leverage that.
Exactly. There's enough material in the specification that you have support for the claims you want that will cover the competitor versions.
Okay, so that sounds like a lot of work. How do you go about figuring out if something is worth the effort of a patent or not?
Oh yeah. Okay. So it's like a multifactorial sort of decision. It can be actually quite helpful to sort of matrix it out on a spreadsheet. But we're looking at. Let me say first what patents are useful for, and then how to make them so. Okay. So what patents do is protect price point, contribute to valuation, contribute to investability, and enable licensing. In a nutshell, that's what patents do. Happy to explain any of those points, but I won't just now because I want to answer your question. So with those things in mind, what we want to look at is for your startup, let's just simplify things and just call it a product startup. The same thing will apply for software startups. But what are the key innovations in our product? What are the features that really make it unique, that will make a consumer want to buy my product over the competitor products, these innovative features. So I want to kind of list them out because we know these are the features that help protect our price point or add price premium. Then we want to say of these features, and then we can sort of rank them or assign some dollar value to them. Then we want to look at the patentability of each of the features, because just because you have a feature that's innovative doesn't necessarily mean it's patentable. So then you've got kind of two dimensions, and I might just leave it there for the sake of not going on forever. But you can see at least that if you matrix that out, there's you're going to have some features being patentable, others not. Some features being highly patentable but not valuable, but not that valuable. So you've got to sort of find the middle of the Venn diagram.
But that's an interesting way of looking at it in terms of the value of the features that you're then able to defend. Mm-hmm. And you're then the only provider of how much money do you end up making potentially from those that can then justify the patent. Yeah,
and it's also another sort of tricky part to conceptualize unless one sort of models it out is just the length of that protection, which is 20 years. Registered designs, by the way, another form of protection that protect the aesthetics of a product. Patents protect function. They last 10 years. In some countries, 16 years. But you kind of want to look at how the features are going to add value over that time frame. Now, it might be, as we're often doing, is we're filing a patent application on features that are not in the current product. No intention of it being in the current product. It's going to be in development, 1.3.4, which is going to be 2026. So that's when the value starts of that patent claim starts in market, and it will extend into the future for the life of the patent, potentially.
Is it worth going into the designs part of thing and explaining what they are?
Oh, yeah. So patents, I think I've probably done a reasonable sort of overview of. Registered designs are used to, let me just give you some examples of what registered designs are typically used to protect in Australia. Garments, sort of a watch, car, the shape of various components of vehicles, big one, tyres, do some work for Hankook tyres. Basically, any physical product, and I know we've got a very clever gent in the room who, Sylvan, who got a US granted design patent on a GUI, graphical user interface. So that's been possible for some time, and another way that designs are used. Yeah.
So the protection is similar? You're saying this is, and for the same reasons? It's saying I've come up with this thing and I want to make sure the world knows about it and can use it, but that gives me a monopoly on that design.
That's right, yeah. So we're I guess it's sort of like an incentive the government offers industry to be innovative and clever in the aesthetics and the design work they put into products. Registered design is a much narrower form of protection than a patent because you can obviously change the way a product looks pretty easily. Most of the time, almost all of the time. Sometimes you get this little niche situation where basically the aesthetics are totally tied into the function of the product. And that's like an alternate situation where you can sometimes get away with, you can file both a patent or design, but you may get away with not having to file a patent and using a design to actually protect function.
My head's hurting. What would an example of that kind of thing be? Like
now you're going to make my head.
Like a Dyson Air multiplier thing or something?
Yeah, so it can be like a disposable part, like a printer cartridge connection interface, for example. It has a particular look to it. It's the only look that's going to work with that printer. Look,
Wow.
HP, I mean, they're filing patents galore, but you could potentially use a design to protect that.
Okay. So I know a lot of our startups are working in software. Are there considerations around software that are important for patents or designs or anything else?
Absolutely. Let's tackle the patent side of things. So there's all sorts of common misconceptions about software patents, and I wouldn't say the misconceptions are overly negative or overly positive. They just tend to be based on the wrong reasons. Let me first say, novelty and inventive step operate in a very similar way to other types of inventions. It's the patentable subject matter requirement that tends to be the issue in software patents. When we're looking at this field, what the Patent Office and courts are looking for is technical solutions to technical problems, not algorithmic solutions to business problems. It really has to be a technical solution to a technical problem. Now, there may be business benefits in the course of providing that technical solution to a technical problem. That doesn't negatively affect anything, but that has to be present. And so we're looking for where the software and where a computer is really inextricably linked to what the invention is doing. Now, of course, if the problem is something around, say, the computer in itself, like you have a solution to process some data more quickly, or use less memory, or even draw less power from some hardware. These are all inherently patentable subject matter because it's technology related. Now, it's not to say other types of software aren't, and probably the greatest example of what I call like a borderline patent that got granted is the Uber surge pricing patent, which I had another look at the other day, and I'm still not entirely sure why I got granted.
How is there no prior art for that, or one-click checkout on Amazon, or
Yeah.
Is that just a case of I have enough money to defend this, so I don't care?
Well, actually, there's that too, but basically they've couched what is fundamentally like a business improvement in very technological terms, and referring to different steps the software goes through in the background as the users selecting whether they want to go ahead with the surge pricing or not. This is pretty clever, but I would say that's really borderline.
Mm. And probably the kind of thing where looking at that patent in 10 years' time, or 20 years, no one is going to get much utility out of that being published. That's just a monopoly without much of a purpose. You could argue.
What do you mean? Like
if the trade-off for patents is publish this information so other people can benefit, and then you get the monopoly, like the benefit there is not that strong.
Yeah, and that's why the Patent Office defers away from granting patent monopolies to business process improvements.
Hmm.
Yep.
Okay. So the freedom to operate.
Yeah.
So it's rare to find any startup that's concerned about freedom to operate until an investor or someone else is saying, hey, we need to do this kind of research. Could you talk people through what that is and what they might expect from that?
Yeah, absolutely. Let me start with an anecdote. I did some work for a software client of ours, web platform-based software. They came to me with a couple of patent applications that they'd identified, and they're like, These seems pretty close to what we're doing. It was patent applications of a very well-known company. I supplemented, say, their search with a bit of a broader search, identified the rest of the patent applications in that family. So there were some children, like we discussed before, that were not granted, like we discussed before. Very interesting situation. So this client of ours had spent $1 million on developing this next generation version of their software. In fact, it's not really next gen, doesn't matter anyway. It was basically not their original product, it was a different product line, but it wasn't next generation. So they'd spent $1 million in product development. Now they've got these patents in front of them, and what I discovered was that their MVP of their this new product did not and could not infringe any of the granted patents or the patents going through because of prior art considerations. That means if they changed the claims in a certain way, they wouldn't have been valid. But every single feature in their pipeline that I was also checking against this group of patents would have been a clear infringement of one or more of the patent applications. So they basically found out, they had no idea, they were completely cornered. They were completely fenced in. They could release this new product, but they couldn't make any of the improvements that they planned to make. So I can tell you as a patent attorney, it is quite difficult being the bearer of bad news in situations like that.
Yeah. What do you do in that situation?
They weren't very happy.
Can you navigate around it, or is that a kind of?
Well, that particular situation, why I mentioned it, was very tough. I mean, very, very tough. Yeah. But yeah, so often what we do try and do is one of two things. When we find patents that are infringed by a client's product, we try and look at ways the client's product could be changed, and so not take all the features of the claims, and so not infringe the claims. Or we try to invalidate the patent. Because sometimes patent examiners miss relevant prior art. And if we, it's happened on a number of occasions, do a really, really thorough search of the prior art base, we find that knockout bit of prior art, and then there's re-examination procedures before the patent office, and I haven't been involved in this, but you could use the courts to invalidate a patent.
Okay, so it's not done, but it's a good thing for different people down the track to understand. So it's something people will probably have to deal with at some point.
Yeah, so with freedom, I would say with freedom to operate, just to give you everyone some perspective, like a freedom to operate search might be $5,000 to $10,000, depending on how much we're looking at, how many documents come back. So it's expensive for a startup. But if a startup is looking at a major build, spending hundreds of thousands of dollars, well, maybe it's a reasonable step to take. In general, things tend to net out, with our clients at least, that if one has $5,000 to $10,000 early on in the startup to spend on IP, and they have something patentable, then generally that money ends up going into filing a provisional patent application. But once that sort of option's considered, freedom to operate search can be a very, very good sort of insurance policy against wasting a lot of development money.
Okay, so I'm going to ask you to put your investor hat on for a different perspective now, because I know you've invested in quite a few startups, like 38 different startups. Yeah. How do you look at the IP of a company that you're about to invest in as an investor?
So I look at the relevance of the IP to the actual where the value lies in the business, so the products that they're selling or the services that they're offering. I want to see, the IP is not just some peripheral, patentable, clever thing, but it's actually protecting the IP, protecting the commercial value of the product in some way. I looked, and this is one of the little advantages a patent attorney investor has, I look at the validity of the IP. So the prior art base, we do my own searches. First of all, look at the searches that have been done on the public record, done by patent examiners, but then maybe supplement with my own searches and see, do I think this patent application is going to be successful or not? Is it going to be granted?
Okay. But that obviously is a positive point, and there's certain industries of companies where it would be more important as well.
Yeah. So, like one client we invested in is Tillida. So they have very clever software involving neural networks that basically runs a pre-processing and a classification algorithm and determine what type of fresh produce someone is putting on the point of sale terminal at Woolworths, right? And it's in Woolworths all around Australia now. They've licensed it out. So, I mean, their IP is invaluable because they're in the. Yeah, there's a few components to the business. I don't want to talk in too much detail, but licensing is part of the business. And if you're licensing know-how and trade secrets, well, that's fine. That works. It's something you can do. Better to have a patent there as a backbone.
Okay, as we start to wrap up, a couple of stories might be nice. So we'll get into the confessions part of thing. Like, when have things gone really well for a client, and when have they maybe not gone so well and could have been avoided?
Okay, I'll tell you a little horror story to start with. This is quite funny. I take it I'm not the only one who goes to the pub every so often, but you see on the bar at the pub, there's a very nice, typically branded mat.
Someone must be making a fortune from those.
You'd think so. But what actually happened was the gent who came up with that very clever selection of foam and with a backing arrangement came to us 12 months after he'd started selling them. So it was outside the grace period. No patent protection was possible. Now they're made and sold by everyone, but they're everywhere. And that would have been patentable.
So there is a 12-month grace period.
There is for patents, and actually now for designs as well in Australia. In the States, also a 12-month grace period, but certainly not in every country, not in Europe, for example.
Okay. So that was a bad example.
Sorry. That's some good examples. Yeah. Okay. Easy. Well, plenty of good examples. So, here's an example of a client of ours that filed a patent for one thing, and its claims ended up being broad enough to cover something quite different and a lot more profitable. Maxim Electrical make water stills, so it makes water potable, drinkable. And they were initially selling their product into developing countries like Bangladesh, and the technology is now being used in lithium mines in South America to process effluent.
Oh, God.
So lucky the claims were broad enough. A couple of, I guess, sort of down-to-earth examples. We all like our coffee, I guess. There's a client of ours, Perfect Milk. They make milk treatment machines that optimize the way milk is treated for a particular cup of coffee. So for cappuccino, it's like this. For flat white, it's like high tech. And they're doing really well selling their machines and licensing their tech around the world. A couple of other sort of, it's like some simple product examples. Kelly Walker founded Clipster. Really, and you can Google it, really simple, over-molded clips, like over-molded magnetic clips. When I first sort of saw the products, I thought, well, that's neat, but I wonder how much of a buck you could make out of this type of thing. Boy, was I wrong. She's doing great selling her clips on Amazon and eBay. And in fact, on that note, I should say, Amazon and eBay have, for anyone who's on the sort of consumer product side of things here, have great infringement mechanisms to stop competitors who are infringing your patent. So if you have a patent, you don't need to go to court to stop someone who's selling their infringing product on eBay or Amazon.
Oh, wow. Yeah. That would be fantastic.
Yeah.
Okay. Okay. I think people have been shocked enough and learnt enough. I've got a few more to get through, but I might leave those because I know there's so much more that we could get through, and like we could be here for hours. What is their kind of to-do list for people to make sure that they're not kind of making the mistakes that some people have made and are getting the most value they can out of what they can?
Okay, so in my experience, the most common issue that comes up is actually around IP holding and IP ownership. Basically, disputes between founders. It's just so common, and so it's very important to have the IP owned by a corporate entity, and there being a shareholders agreement that governs, how the operation of that entity, including transferring IP from the founders into the company so that the company owns it. Otherwise, you can have this situation where two co-founders, best of intentions, start off down this path together, put both of their names as applicants, and irrespective of who's the inventor, and both then have equal rights to use that IP however they want in the future. Obviously, and possibly in competition.
Got it. So equal, unlimited rights to just go nuts with it.
The second thing I'd say is, and I'll send through, and I've got an IP due diligence checklist. I'll send through, you can check.
We might put it on the link below on this video, so if you look in the comments, you'll be able to find it.
Yeah. I should also say, while you're going through that, if anyone has any questions or doesn't understand any part of it, just get in touch. But the second most common issue is, I'd say, inadequate patentability searching. So a patentability search, in general, best performed before you file a provisional patent application, if finances allow, because then you can tailor the claims of the patent application around the prior art. And then I think like freedom to operate, these are all sort of the last two, like patent considerations, but freedom to operate is also, if you're going to make a big investment, and also on the trademark side, if you're going to make a big investment in a brand, for goodness sake, do a trademark clearance search in all the markets that you're interested in operating in. Yeah.
Okay, piece of cake. This has been fascinating. I can see people are kind of getting to-do lists going around, getting some provisional patents going each year and figuring out how to do something broad that might be used in a lithium mine. But I think they'll be making a beeline to yourself as well for advice, as they should.
Most welcome. Yeah.
We're now going to turn off the camera and go into private Q&A, where some even juicier stuff is going to come out. For anyone watching at home, I'm sorry, but come and join us every Friday at 3:30 at UTS Startups Central. And for now, please join me in thanking Chris Baxter from BaxterIP.